Okay, good afternoon. Welcome to a very empty welcome to Yorkshire offices here in the centre of Leeds. Empty because, of course, most of our staff, well, in fact, all of our staff, bar myself, are working from home. And social distancing, of course. Like many other organisations out there, we've had to furlough quite a significant number of staff as a practical measure to keep the business going during these extremely difficult times. The decision we took was to furlough just staff that can't actively work at the moment, so lots of our event staff and lots of our face-to-face staff, while still keeping that balance of maintaining a service for our paying members and the wider public at large, specifically within the tourism industry. So that's a welcome from me. My name is James Mason, the Chief Executive of Welcome to Yorkshire. And before you ask, no, I didn't expect this in my first 4 months in the role, so it's a real challenge that's just got a little bit bigger. A little bit of background as to what we're doing now as an organisation. Principally, we're responsible for promoting tourism and the tourism economy in the county, welcoming anyone from all over the world, globally, nationally and regionally to the county. That's proving extremely difficult right now. So we're of the mindset of keeping the kettle boiling or keeping Yorkshire at the forefront of people's minds when we come out of this period of lockdown. Yorkshire's a huge county, and in fact, you know, I've heard it described as being a country within a county. We've got wonderful landscapes, landmarks, people, food, drink, festivals, a number of things that we can really celebrate. We don't always have the best weather, but over the last month, certainly we've had a fantastic April, and that's probably heightened everyone's thirst to get back out and see what we've got to offer. So what have we done? We've run a number of online campaigns and seen some real digital growth recently via a campaign called the Yorkshire Days In campaign. So things that you can do at your home right now if you are furloughed or if you're still working, if you've got kids at home. And we appreciate that's difficult, but we're trying to keep the Yorkshire vernacular at the forefront of everyone's mind. That Bolton Abbey's, still one of the most picturesque parts of the county, the country, the world. That our Yorkshire coastline is up there with some of the best in the UK, some of the cleanest beaches in the world. So when we come out of this, plan now what you want to do. Our World Cup of Yorkshire has pitted some of our natural landmarks up against others. Our physical buildings, such as the York Minster, against the wonderful Peace Hall in Halifax. And only just this weekend we had the World Cup of Restaurants, so 32 restaurants all going head to head from all across the county, and we've asked people to vote. We've seen unprecedented success with these campaigns. 1 million impressions of the first one, 80,000 individual votes on a couple of them as well, showing that people want to interact with some of our content that might not necessarily be applicable right now, but it's building up that thirst for when we're on the other side of it. We've launched a voucher scheme whereby all our members can upload a offer to our website, and I think we've got over 120 individual working companies that are offering vouchers at this moment in time, whereby you can book it, bank it, but enjoy it later. That commitment to paying it forward, if it's a spa break at Grantley Hall, or if it's a visit to Lightwater Valley or fish and chips on the Whitby coast. Our magazine, This Is Why, has gone digital for the next 3 months. So again, something that we're trying to offer partners as an advertising opportunity. This webinar today is brought to you in conjunction with Irwin Mitchell, who are one of our Y30 partners. So we're delighted to have our colleagues from Irwin Mitchell. I'll go on to introducing a couple of our guests this afternoon. But Irwin Mitchell are a national award-winning law firm operating since 1912 when they opened their first office in Sheffield. They're a Y30 partner, so they sit at the top table of our corporate structure and have been loyal to Welcome to Yorkshire for a number of years, and are offering support today by answering your specific questions with regarding funding, furloughing, employment law during this COVID-19 pandemic. So I'll just introduce our guests. And then I'll just finish on a couple of other things that Welcome to Yorkshire are doing and how you can contribute today, but going forward. So on the call with me today, Hannah Boys, solicitor, answering any employment law questions. I mentioned furloughing. I don't think any of us, maybe Hannah can answer this, knew what the term furloughing was 4, 5, 6 weeks ago. I think we're all experts to a point in what furloughing is right now. And also Doug Robertson, specialising in restructuring, recovery, and an insolvency partner at Irwin Mitchell who can answer finance and funded related questions, which of course are so important now, especially if you're a business within the tourism sector, a bed and breakfast, a restaurant, a pub, and you're on lockdown. You need face-to-face interaction, you need cash in the till. So Doug and Hannah can answer some of those questions. If you'd like to get in touch, you can join us on Twitter or on Facebook. The easiest way would be to send in a question via Twitter at our Welcome to Yorkshire account. That's Welcome to Yorks, or our WTY membership account, or myself, James Mason _78. So we'll be checking Twitter for the next hour and an hour and 10-15 minutes or so. Okay, so let's start then. So first question, and please send them in as the afternoon goes on. Hannah, I'll give you the chance to answer this first, but also say a quick hello to everybody and I suppose the challenges that you're facing. But a question that's already been sent in to us would be, please can you explain, and this is specifically with furloughing, how you can calculate what happens with parts of years, for example, if there is a going rate for topping up beyond the minimum in terms of furloughing. At what date must notice be given in case furlough stops on the 30th of June? So quite a technical question, so I'll repeat it. And a lot of firms going to do that now as a precaution. So taking into account furloughing ends on the 30th of June, irrespective of a continuation of that. And how would you reasonably consult and what criteria should there be for losing some but not all staff? Can such notice be open-ended, so it can be extended if furlough is continued, and therefore you don't want to do any such thing but planning in advance? So just to abbreviate, can you explain very quickly how furlough works, how to calculate that if there's part of a month or part of a year's, for example, and then what you think may go on after the 30th of June and how firms need to allow for that precaution? Is that okay?
Yeah, thank you. Thanks, James. Thank you. So just to sort of, I suppose, by way of background, you're absolutely right. No one really knew what furlough was until about a month ago, I think, and it's something that businesses and employment lawyers alike have been grappling with. Since then, people may be aware of government guidance that has been issued and is being updated. The guidance has been somewhat ambiguous in certain areas, which does make it tricky for businesses to know what to do for the best. So I'll take the question that you asked. The first question kind of breaks down, as you said, into a few different areas. I think the first point was in relation to how to calculate a redundancy payment. So if you furloughed somebody and subsequently you determined that actually you need to make them redundant, that is something that is relatively straightforward and is to a large extent largely unaffected by furlough. So we calculate a statutory redundancy payment based on the number of years service that somebody has been employed with the business, and also taking into account their age, and then applying a weekly cap on the amount. So the maximum length of service that we can take into account is 20 years, and there are various different age factors. So if you are over the age of 41, you get 1.5 weeks pay for every complete year of service. If you're between the ages of 22 and 41, you get a week's pay for every year of service, and if you're under the age of 21 or 21 and under, then you get half a week's pay for each complete year of service. So on the part bit of that question, it's complete years that we deal with. So you have to have complete years service. So we use the number of years service, we use the age factor, and then we look at what those individuals are paid for a week's work. And there's a statutory cap of £538. So that, in a nutshell, is how we calculate that. In terms of how that's impacted on by furlough, well, if somebody works normal working hours, if they work the same hours every week and they're contracted to work those weeks, then it does appear that any redundancy payment should be based on their pay that they were receiving prior to being furloughed. So people will probably be aware that under the coronavirus job retention scheme, the government will pay 80% of earnings up to a cap of £2,500. For employees who have normal working hours, we anticipate that redundancy payments will need to be based on their pre-furlough wages. However, for individuals who don't have normal working hours, so for example, those working ad hoc hours, those on 0 hours contracts, there is a question mark as to whether or not the redundancy payment will be based or take into account the money that they received while they were on furlough. It's not been confirmed by government guidance. It's unfortunately one of the areas that has a bit of a question mark over it, but it's something to bear in mind. I think the second part of your question was in relation to topping up the minimum. And I think there are two potential ways to interpret that question. I'm not sure whether it was asked in relation to topping up the government cap of 80% for furlough. So employers are only required to, or the government will reimburse employers 80% of wages up to the £2,500 cap. There's no requirement for employers to top wages up to 100%. It's an entirely a matter for the business if they want to do that. The same applies for statutory redundancy payments. So if a business is looking at making people redundant, the statutory redundancy payment is the minimum that those employees will be entitled to, unless that employer has something in their contract of employment, or if they have a redundancy policy, for example, that enhances the redundancy payment. Other than in those circumstances, there wouldn't be an obligation to top up the redundancy payment there. So I think that answers the topping up part of the question. Yeah. I think the next part of the question related to notice and how you go about that. And again, I think that can be broken down into two sort of scenarios. I think the first is where an employer is wanting to give or is wanting to bring the furlough leave to an end. So what notice does the employer have to give to the employee in those circumstances? Well, that depends on what was agreed with the employee when you put them on furlough. A lot of employers have been drafting the agreements in relation to furlough, or the letters that they're sending out regarding furlough, so that they're quite open and enable the employer to sort of say, well, when the government brings this scheme to an end, you will come back immediately, or when we need you to come back, we can end the furlough leave immediately. So what notice applies in those circumstances will depend on what was agreed with the employee at the beginning of the furlough period. The second possible interpretation of that question is what is the notice that we need to give to an employee to make them redundant? Well, that will depend on what the contract says. What the employment contract itself says about notice will apply in the same way, unless the furlough agreement says something different.
Yeah. On that, Hannah, just something I've picked up in listening, and so I suppose it's relevant for lots of business owners or employees right now. Can you furlough an employee and then bring them back and furlough them again? So that's a question that's come into us. Yeah,
absolutely. So the minimum period that you can furlough an employee for is 3 weeks. Each period of furlough must be a minimum of 3 weeks. That's in the government guidance, and that's one of the requirements or one of the conditions to make a claim. But there's nothing to stop an employer furloughing an employee for 3 weeks, bringing them back to do some work for a week, for example, and then furloughing them again for a further 3 weeks. So that's absolutely, under the guidance, that's absolutely permissible.
Could it be as little as a day, for example? So let me give you a scenario. You've furloughed a member of staff, but you've got a very important call that you want to bring them in on because they've got some specific expertise. You bring them back for that call, you furlough them again.
Yeah. Wow. Yeah, you can do. Yeah. So the key thing really about furlough is that it has to be agreed between the employer and the employee. So I think what I would caveat my answer with is the employee would need to agree to that. But yes, in the government guidance specifically says that you can place employees on furlough for a minimum period of 3 weeks. When they return to work, they must be taken off furlough, but they can then be furloughed multiple times, and each separate instance must be 3 weeks. So there's nothing in the guidance that suggests you couldn't bring them back for a day and then furlough them again for another 3 weeks thereafter.
Okay. As I say, you're listening to a joint webinar this afternoon between Welcome to Yorkshire and Irwin Mitchell. Hannah's answering the first couple of questions. So Doug, apologies that you're in the background there, but give us a wave to tell everyone that you're still here. We'll come to you shortly. But the first 2 or 3 questions are for Hannah. Next one up, Hannah, and again, this is sent in by one of our members. Can I give notice to terminate an employee's contract even though they are furloughed?
Yes, you can give notice to terminate a contract of employment, even if they're furloughed. So according to the guidance, there's nothing to prevent you giving notice to terminate a contract of employment for an employee who's on furlough. So what that means is that employers don't need to bring employees off furlough and back into the business in order to give them notice to terminate the contracts. There is perhaps a kind of a follow-up point on that, which relates to notice pay and how much employees who are furloughed should be paid while they're essentially on note or working out their notice, but they are furloughed. Unsurprisingly, there isn't any clear guidance on that at the minute, and it's quite an ambiguous and tricky area because it depends on how much notice they're entitled to, and it could also depend on why they've been furloughed in the first place. You know, some employees are primarily furloughed because the employer has no work, and some are furloughed because of childcare commitments. So what I would say is that if businesses are giving notice to employees and those employees are on furlough, yes, they can do that, but they should take some advice in relation to what notice pay that employee is entitled to.
Okay, I think that fully answers that question. Next one, just looking through what's coming in as we speak. Can an employee take holiday while they're furloughed? So they might not be able to jet off anywhere nice and sunny, but can they take time off, you know, a week with the kids? Of course, we've just had Easter, or maybe a couple of days if it was your birthday, or just some downtime. So can an employee take holiday while they're currently being furloughed? Yes,
yeah, they can do. So that's one point that wasn't clear at all initially when the scheme was first introduced and the guidance first issued, but the government guidance now specifically says that you can take holiday whilst on furlough. The legislation that deals with holiday requires holiday pay to be paid at the employee's normal rate of pay, or where that rate of pay varies, it's based on 52 weeks, the last 52 weeks of pay. So you should get your usual pay while you're on holiday if you're on furlough, and employers will be obliged to top up the amount over and above the 80%, for example, if the employer is just paying the 80%. In relation to bank holidays, the same applies. So if you usually work bank holidays, the government guidance says that your employer can agree that it's included in the grant payment. And if you usually take the bank holidays as leave, then your employer would have to top up your holiday pay to your normal pay. Does that answer that question?
Yeah, I think it does. And as I mentioned at the start, if anyone is joining us on the live web link, they can email us in. So I'll just go through a couple of housekeeping tips for anyone that's on now. You can email us at info@yorkshire.com if you have any specific questions for Hannah or Doug, or even myself, and Welcome to Yorkshire in that matter. There may be specific questions for Irwin Mitchell that Hannah or Doug can't answer today. No problem. We can certainly divert those questions to the Irwin Mitchell team, and maybe they can respond in person to you. Equally, for info@yorkshire.com, we can answer any member related questions. It's important just to confirm what Welcome to Yorkshire are doing right now, along with Irwin Mitchell and all our partners, but also people outside the Welcome to Yorkshire family, is try and come up with a recovery plan going forward to make sure that we can protect this £9 billion industry, which is tourism, but the bigger economy at large as well. We're trying to preserve this going forward. So we're pulling together industry experts, not just within tourism, but actually business experts like Irwin Mitchell, to build a recovery plan to save this industry and the many associated businesses with it. In addition, we've a medium and long-term strategy that prior to COVID, 19 we were going to unravel, which includes personal membership, which includes a Yorkshire gift card so that you can buy products, commit to it now but spend it later, and really promote Yorkshire as a place to visit primarily, but live, work and study. So please send your questions in. Hannah, thanks for the first answers for the first 2 or 3 there. On furloughing, Hannah, can we guess how long this may go on till? It's up until the end of June, but do you think the government will probably mid-May, mid-June rethink this and look at the wider economy and the cost associated with that? That's for you, Hannah, if you want to answer it. You may not know, but it's probably the question that's knocking around the Irwin Mitchell office right now. It's been extended. Will it be extended again and again? Just off the top of your head.
Yeah, I think that initially when the scheme was first introduced, it was anticipated that it would be extended, and it has been extended. So I suspect that depending on the government finances and state of the economy in late May, June, then there's every possibility that it might be. Clearly, if things continue in lockdown to this extent, then arguably it would need to be. There's just one point that I'll just mention as well. It's sort of on the holiday pay point that we were discussing before. But also kind of as a word of caution really to all sort of businesses dealing with the job retention scheme, which is furloughing, that the government guidance at the minute specifically says in relation to holiday pay that during this unprecedented time, the government are keeping the policy on holiday pay under review. And we have seen many iterations of the government guidance, and it isn't always announced that the government guidance has been updated. So it is really important to just bear in mind that the government guidance is regularly updated. It is a bit of a moving feast as well, like this is across industries and across the economy, but it's a bit of a moving feast and it does keep changing. So, if businesses are in doubt about what to do take advice, because obviously at Irwin Mitchell, we're keeping across all of the developments and keeping on top of everything.
Okay, yeah, Hannah, good point, well made. And I think it was important to sort of just underline that and bring it to people's attention. So Hannah, we'll probably come back to you after we've answered a couple of specific questions to Doug, if that's okay. So if you can stay there, and again, if people want to tweet in, you can do so at Welcome to Yorks, that's YORKS, on Twitter, or at WTY Membership. Or Irwin Mitchell's, you can get in touch with us in all those ways. So Doug Robertson, thanks for joining us, Restructuring, Recovery and Insolvency Partner. Doug, so I suppose we need to look at funding options. The government launched yesterday the bounce back loan, which has to be applauded. But if I'm a business owner, loan means debt, deferred debt, even if that's after a year or so on and so forth. And this particular question comes in from a member. Before I ask that, is there anything that you'd like to start with in terms of what funding is available? And actually, there's a question that has just come in from one of our members about a specific issue that I'll come to at the end. But if you want to just start on the funding that is available for businesses, please.
Hi, James. Thank you for that. Just to run through a quick sort of revision of what there is out there. Hot off the press, I think last night was the bounce back loan, and that is aimed at the smaller businesses, and I suspect is in response to a bit of a criticism about lack of take up of the Corona Business Interruption Loan, or CBIL, and is fully underwritten by the government. So basically, it goes in stages of size of turnover. There's the starting point's the bounce back loan, then there's the Corona Business Interruption Loan, or CBIL, and then the Corona Large Business Interruption Loan, and then for large corporate, the COVID Corporate Finance Facility. And then I'll touch on a couple of other grants or reliefs that are out there which can help. But I suspect that the key two funding packages are the bounce back loan, which isn't available yet, will only be available from the 4th of May 2020. It's for small businesses, and they're able to borrow up to £50,000 over 6 years. So taking your point there about it being a loan on the balance sheet, that is entirely correct, and that is something that directors have to have an eye to. Most of these packages, and certainly when we get onto the CLBIL, the large business loan, you have to show a business proposition or a repayment proposition that's viable and would be seen as being viable by a lender. That's for both the CBIL and the corporate, the Corona Large Business Interruption Loan. The good thing about the bounce back loan is it's 100% underwritten by the government. The government will pay all the fees and interest for the first 12 months, and it excludes excludes the same business as CBIL. So things like banks and public sectors and further education cannot apply for it, and you cannot have a bounce back loan and go for the Corona Business Interruption Loan. The Corona Business Interruption Loan, to compare to bounce back loan, is for a bigger amount, so it's up to 5 million over 6 years. Again, the government will pay the fees and interest for the first 12 months. The government will guarantee of up to 80% of it, and that's really why I think the bounce back loan has come in, because at 100%, hopefully less due diligence will be required, and therefore the access to funding for those smaller businesses will be quicker out the door, because the cash needs to be in the accounts now. The businesses that qualify for CBIL will have a turnover of up to £45 million and must be UK based. If you're borrowing more than £30,000, you have to not be in financial difficulties as at the 31st of December 2019, and no personal guarantee can be required for loans of up to £250,000, and any personal guarantee liability will be capped at 20% of the debt value over £250,000. The Corona Large Business Interruption Loan is very similar to the CBIL, but for businesses with a turnover between 45 and £500 million. And unless anybody wants to ask a specific question, I won't go into the COVID corporate facility, finance facility, because it's for very large businesses and probably won't be relevant to SMEs. But if you do have any questions on that, I can run through the criteria. And just so we're aware, the other help from the government available is business rates. All retail, hospitality and leisure business rates will not be payable in the period 2021. There's a small business growth fund grant of up to £10,000 for businesses with a property with a rateable value below 15,000, and then there's a retail, hospitality and leisure grant of up to £25,000 for businesses with a property with a rateable value between 15,000 and 51,000. And again, in terms of assisting with cash flow, there's a VAT deferral for 3 months from 20th of March to 30th of June. And similarly, a tax deferral is automatically available. And we've talked about the job retention scheme and furlough, and effectively the self-employed version of that. So that's just a quick summary back of the finance and support that's out there. But taking on board your comment, James, that loans are on the balance sheet and will need to be paid off, and so that naturally is going to put off some business owners. But at the same time, with needing cash to survive and pay immediate bills, then it may be there is no or little option or little other viable option but to take on the loan. So that will deal with that bit. And I think, did you ask a question at the start there, or was there a question?
I'd started to ask a question, and then I thought it's probably better to frame it with all the funding that's available, and it actually may instigate some questions. In fact, I have just had a question in, but we'll save that until nearer to the end. And it does refer to businesses that are available, businesses that qualify for a grant and those that don't. I know that you can't answer this because I don't think the government can, but I suppose it's just a case of now that you've framed options available. So if you don't qualify for a grant, there's a loan available. And I think your point about whilst it not being ideal because it's still on the balance sheet, it's a needs must scenario, isn't it? You know, if you need instant cash, never before have you been able to apply for X £1,000 with no interest rate. And for a year, if that's what you've got to do to keep your business going, perhaps take it and hope that things change along. I think we've seen with the government the furloughing option came out to preserve jobs, and then the big clamour was self-employed people saying, what about us? That was clearly a sort of utilitarian point of view, whereby protect the masses first, and then they put in a provision for those that are self-employed. So I think a lot of the government, like a lot of us, are thinking on their feet right now and finding problems out after they've solved one. And I think that's a fair state of summarisation, if that makes sense. Okay. Unless you've got anything to say on that, Doug. You made
I was just going to come back in. I suppose that there's one point that the government was suspending the directors' duties in terms of wrongful trading. So to encourage business owners not just to sort of hand the keys over and close the doors, the government's made it the wrongful trading regime more lenient. I guess the question I have with that, being a restructuring lawyer, is, with the benefit of hindsight in a couple of years' time, how will that play out? And so, as with anything, it's difficult to say with absolute certainty, but if you are absolutely comfortable that with a cash injection you can fund that cash injection and be able to trade on, then that's an easy decision to make. If you're absolutely certain the business isn't going to survive Corona or no Corona, then I think that's an easy decision to make, and there'll be that grey area in the middle as to whether or not you take the funding. And I suppose the overriding ethos behind the government legislation and what it's asking society to do is to be almost a bit sympathetic and not judge with hindsight. But if it allows the business to survive where it would have been fine but for the Corona, that's what these funding packages are there for.
Yeah, just on that, so on the bounce back loan, I've not looked into it in detail, but what's the what collateral do you have to put down? Who's the guarantor? So if I'm a small business, I'm a bed and breakfast, or I'm a tea room on the Yorkshire coast, I apply for a £10,000 business loan that has got 0 interest for the first year. And in year 2, I'm starting to pay it back, but I do feel the pinch and we go bust, we're insolvent. Who pays the loan back? Have I signed a guarantee on my house, or someone else has acted as a guarantor? Would you know that information yet, or is that too new?
I think I do. Basically, the answer is because it's 100% government backed, lenders shouldn't need a personal guarantee. And don't forget, lenders can't ask for a personal guarantee on the CBILS where the loan's under £250,000. So if you've got a limited company, then it will be the company who's liable for that debt. Again, if you're a sole trader and you're borrowing your own name, you will be liable. So we need to be clear on that difference. But if it's a limited company, it will be the company who's limited for that, liable for that debt. And I suspect lenders will either not ask for security or will not be allowed to ask for security because the government's backing it 100%. And if the government's backing it, why would you need to get personal guarantees? I mean, lenders don't like enforcing personal guarantees, and so it's a much easier sell reputationally to ask the government to pay the loan.
Okay, so if we can move on to some specific questions now from our members, if that's okay. So I'll read this out. I'm a small business owner in the hospitality sector. I have only been trading for 1 year, so 2018 to 19, and naturally due to the investment needed in year 1, I've made a loss and therefore no income. So that's quite understandable, quite normal. I have year 1 accounts and year 1 self-assessment available. Am I and others in my position able to claim for the self-employed grant? So I understand the point there. So they're a business, they've been trading for a year, but they've made losses. Are they able to claim for self-employment grants that are available that we just discussed?
Yeah, so this has been one of those slightly unfortunate examples of where the self-employed furlough, if you like, doesn't cover every situation. If we look at the 5 basic requirements for a self-employed individual to claim the income support scheme, those are: 1, you have to have submitted your self-assessment tax return for the tax year 2018 to 19. 2, traded in the year 19 to 20. 3, are trading when you apply or would have been trading except for coronavirus. 4, that you intend to continue to trade in 2021. And 5, have lost trading profits due to coronavirus. And the other thing, just while we're touching on the overall scheme, your trading profits have to be no more than £50,000 to qualify, and at least half your total income for the tax year 18 and 19, or the average of tax years of 2016 to 17 and 17 to 18 and 18 to 19, have to be from the self-employed income. And finally, you also have to self-certify to the government your business has been adversely affected by coronavirus. If you can satisfy all those criteria, and there's quite a few there, then you would qualify. If we turn specifically to Karen's question, we would need to check, and I'm suspecting the answer to this is no, but we need to check if she submitted a self-assessment tax return for the year 18-19, and that she traded last year. And I think it's reasonable to assume that she did trade in 2019-20, but I question whether or not the self-assessment tax return for the year ending 19 would have been submitted. Further, the other concern from the question is that she uses the phrase trading profits, and we know HMRC work out trading profits by taking the turnover and deducting allowable business expenses. But if you don't have profits, you have nothing effectively to claim against. You can't show a loss of income. So I suspect in that case it would be doubtful that she could claim that particular grant.
Would you, if in the 2 or 3 years prior to that you'd been self-employed? Not part of the question, I'm just thinking off the top of my head. So year one, you've made a loss. So as you say, you've nothing to claim against, but year 2017, 16, 15, you were self-employed. Are you able to go back like that?
It's a good question, because it takes account of your average, or it takes account, the threshold requires that you're, for the tax years ending 17, 18 and 19, the income's going to be at least 50%. I would need to double check on the qualifying period, and I'll do that. Hopefully I'll come back with an answer to that before the end of this presentation. Yeah,
that's fine. I'm just proving to everyone it's live, and that we're taking on board questions that are coming in, and it's not all scripted. And having been a business owner myself, I'm just thinking things through as we go along, just to see how it might play out. So as we mentioned, Doug and Hannah and the team at Irwin Mitchell are happy to take any questions offline. It's a movable feast, so we don't expect to know every answer right now. But next question, and this has come in from, again, a business owner who is saying, I'm still considering attempting to raise finance through the government's business interruption loan scheme, so CBILS. I would be looking to borrow over £250,000, so £250,000, so quite significant. And I'm concerned about the extent of the personal guarantee, we referenced that earlier, that the bank might require. I'm particularly concerned about the prospect of including my home as part of the guarantee. Could the bank force me to do this? So a variation on the question I asked previously on personal guarantees. So business interruption loan scheme, £250,000. Could the bank enforce any guarantees, including this person's home?
Yeah. We're into the coronavirus business interruption loan scheme fund here. So unlike the bounce back loan, it is only 80% government backed, and that leaves 20% at risk for the lender. Initially, you may remember, uptake was low, and there was criticism, I think, of lenders for the extent of due diligence because the money wasn't leaving the government scheme and getting into businesses' bank accounts. So it was revamped somewhat, and basically it was made a condition that a personal guarantee couldn't be required for loans of £250,000 or below. So at that point, again, the bank would have to rely on its due diligence, hopefully the fact that the business was viable and they could see it being repaid, and the fact that if it all went wrong, they'd get 80% back via the government, which then de-risked it considerably. Over £250,000 though, the lender can require a personal guarantee for the loan, or for the 20% balance. And the straight answer is they're not allowed to require that the principal private residence is given as security to for the guarantee, which in some ways is reassuring. And the other thing is, banks, generally speaking, will tend to shy away, well, certainly high street banks tend to shy away from taking a residential home to secure a business debt, because for treating customers fairly and reputational purposes, it becomes very difficult at times to enforce that. So maybe no surprise there, but some of the non-high street lenders may still do that, but they can't under this scheme. But the question, I suppose, and I'm putting my sort of hat on as an insolvency side of our business, insolvency lawyer, is if, say, we take a scenario where 3 years' time, the business unfortunately hasn't been able to survive, has folded, and say there's a balance of the loan due of let's say £500,000, of which 20% is due, so £125,000. If the guarantee was called on and you were unable to pay, whilst the lender wouldn't necessarily have a mortgage or charge over your home, they could potentially, in theory, obtain a court order against you, a judgment, and then secure that with a charging order. Now, I question whether or not they would do that again for reputational purposes, but I don't think there's anything I've seen that says they specifically couldn't ever look to do that. And the other thing is, again, even more of a doomsday scenario. Hopefully not being too negative, but let's be frank and speak about the risks. The risk again would be, if you were unable to repay it, and often with a business failure comes an element of personal debt. You could potentially go bankrupt, and then at that point the family home would again be in play. So whilst it's reassuring and very reassuring below 250 that no guarantee can be requested, where you do have personal liability, you have to be aware it's not without risk, and if the loan cannot be paid back, or if there's a significant risk of that, then it's worth taking careful advice, because it can come back to you.
Okay. If I look down anybody, it's only because I'm trying to read tweets and information coming in at me. I'm not asking what's for lunch. Don't worry about that. I'm just busy scrolling through information, etc. We do have a question here. Question number 3 for yourself, Doug, if that's okay, Hannah. Stick with us. So I work in the retail sector, and we are currently looking at accessing the Retail, Hospitality and Leisure Grant Fund. There seems to be quite a lot of terminology. For example, I've read somewhere about the expanded retail discount grant, but this seems to relate to business rates. Could you sort of expand on this, Doug, and piece this together for me, please?
Yes, yes, I can. So again, there's effectively 2 sort of property-related grants. There's the SBGF for businesses that own a property with a rated value of up to 15,000, and then the Retail, Hospitality and Leisure Grant for businesses that own a property with a rateable value between 15,000 and £50,999. The grant in the bigger one is 25,000, and the grant in the smaller one is £10,000. In terms of the terminology, you're eligible for the Retail, Hospitality and Leisure Grant Fund if you're eligible for the expanded retail discount scheme. And agreed, the expanded retail discount scheme did pertain to business rates, but in this context, it's just using the same eligibility criteria for the RHLGF. So again, providing the rateable value of the property is less than 51,000 or 50,999, and none of the other exclusions apply, then you'd be eligible. The other thing to be aware of, shops are now included in the expanded retail discount scheme, and so the person in retail here should be able to get it, providing the qualifying the other criteria. And it was expanded this year to include certain other shops, such as letting agents and estate agents. The excluded properties basically are, or the exclusions would be the business couldn't be insolvent, and it can't be what's known as a property for personal use. So we're talking about sort of a stable or a beach hut sort of thing. And so basically, depending on the size or also the amount of the rateable value, those 2 grants are available.
Okay, just to confirm, we're on a live webinar between Welcome to Yorkshire and Irwin Mitchell. We do have some live questions, Doug and Hannah, that are coming into us, but we'll save those to the end. So thank you to Karen, to Fiona, to Paul Grace, to Roddy Hamilton, who've emailed in just after we started at 1 o'clock, but we're going through questions that were sent in prior to being live, so we certainly will have time. We're hoping to go on till 2, but we can probably extend that to 10 past, quarter past, as long as Doug and Hannah can stay with us. So another question or 2 for Doug before we go live to those, if that's okay. Next up, and this comes back to terminology, Doug, to some extent. What has a pandemic been classified as in terms of legal terms? And if the word pandemic is in a legal contract, then would the contract be null and void? So anyone who's familiar with any particular contract will understand the force majeure clause, and that's come into question, hasn't it, over the last 3, 4, 5 weeks? What is an act of God if it's not a global pandemic? But what actually is a pandemic classified as, Doug?
Yeah, so if the word actually appears in the contract, so it says a force majeure, or it shall include, as you say, act of God, etc. And if it includes within that pandemic, then that is relatively clear. And that's where it would usually be found. It would be, the definition of what is a force majeure, and then the contract will say if there is a force majeure, then the parties don't need to perform the contract, but each contract will define what exactly happens. But usually, effectively, the ethos is if the contract cannot be performed because of an act beyond either party's cause or contemplation, then they should each be released from their obligations and not be liable to one another. There has been quite a bit of debate as to whether or not the coronavirus pandemic is a force majeure, i.e. if the contract just says any event which is a force majeure, would it qualify? And I'd have to defer to sort of the commercial specialist as to what the current thinking is on that. But again, if you look at the actual wording of the contract, if the word pandemic appears, then it's been classified that by the World Health Organization. That would seem to me to be a strong argument. And if it doesn't appear, it will probably depend on the wording of the rest of the clause and what it was intended by the parties.
Okay, thank you, Doug. Just to say, we've got a number of questions that are coming in live, which is great. It means people are listening and interacting. Some are specific to Welcome to Yorkshire, so I'll give you both a break for a second before I come back to you, Doug. But this came in from Roddy Hamilton at 1:06. Is it likely that low-density glamping sites will be allowed to reopen earlier than hotels? If so, when this might be? So, Roddy, on this point, the big question right now is what tourism will look like post-COVID-19. I think we all were hoping that up until recently, and Professor Chris Whitty and the Prime Minister just the other night said that, the new normal may mean that we come out of this towards Christmas, and that was a real sucker punch for us, specifically in the tourism industry, and particularly for yourself, Roddy, if you have a low density glamping site. But I think safe tourism is going to be a word that's going to be, or a phrase that's going to be used a lot, and that will be self-catering. Camping sites will naturally be the preferred open spaces or accommodation providers over hotels, bars, restaurants, etc. Open spaces like Bolton Abbey, the Yorkshire coast, of course, where you can exercise self-discipline in terms of self-isolation, would be our thinking within the industry. There's been nothing to suggest that will be the case, but the natural succession of thought processing would be that yes, low density glamping sites or camping sites, self catering accommodation would be open before hotels and restaurants. But don't quote me on that, because we've had nothing from the government, but that's the intelligence that's coming out of the market right now. A couple of anonymous questions coming in that we'll go through shortly as well. And as I mentioned, Paul, Karen, Fiona, we will come back to you, I promise, so please stick there. But just going back to some of the questions that have come in, Doug, last one for you before we bring Hannah back in. Any top tips for negotiating on deferred payments of utility bills and rent? And that's actually something that comes into Welcome to Yorkshire quite often. So people don't want to renege on a bill or not pay it because they don't want to be prosecuted for that. Plus, we're all in this together, so you don't want to, rob Peter to pay Paul. And at Welcome to Yorkshire, we've brought in a 3-month membership freeze for members so that we can demonstrate that we understand that cash flow is difficult. But any tips for negotiating deferred payments of utility bills and rent, etc.?
Yeah, well, the utility suppliers as statutory suppliers occupy a fairly special place in terms of, we need gas and we need electricity. So the first thing is, given the prevailing circumstances, I suspect they would not be looking to cut off either businesses or homes, quickly or at all in these circumstances. In much the same way as banks aren't taking possession action on mortgage arrears or taking any action on certain types of arrears. So I suspect it would be the usual advice I would give when dealing with a bank, or effectively your utility provider becomes a lender, an involuntary lender, because you're unable to pay the money you owe them, which is, if you speak to them, and this is an educated guess, so if you hear, if there is somebody's got an example to the contrary, please do let me know. But my suspicion would be that they will take a lenient approach, that they will deal fairly with customers, both business and residential, because the government really does want businesses to survive this and for the economy to come back in as intact a position as it can be. So I suspect they'll be lenient. I suspect if you communicate with them, they may be open to things such as payment holidays or reduced payments, in many ways, like the banks have done for certain borrowers. The other point, I guess, would be they, in most cases, don't have any security, and will know that if businesses are distressed and struggling because of lack of income and having to take on additional debt because of borrowing from government support, that if they were to somehow push too hard and force a business either into a form of insolvency or even to doing a deal with its creditors, that would probably be counterproductive. The best, it's always said, the best security or way to get repaid a debt is for the business to be successful and continue trading, and therefore if the utility suppliers push hard at this time, it's not really going to help them or anybody else, because that would leave businesses failing at a time when their assets wouldn't be particularly easy to sell. So my suspicion, or my usual best practice advice when dealing with a large institution, is talk to them, be upfront with them, and try and come to negotiation. If you just ignore them, that's when they tend to get more, take more enforcement steps.
Okay, perfect. So we'll go to some of these live questions now then. Hannah, are you okay to take a question and give Doug a little bit of a breather? Yeah, okay, I'll read this out to you then. So this has come through anonymously, but okay, we'll still ask the question. If an employee is made redundant whilst on furlough and receives a redundancy amount, and the reason is linked to the impact of COVID-19, can an employee ask the employer to rehire them under the job retention scheme for the purposes of furlough and the period of furlough? I'm assuming the business doesn't need to say yes. Do you want me to repeat that, or?
No, that's okay. I've got the question. So in short, the answer is that the employer doesn't need to agree to say yes. So the assumption there is correct. As I mentioned earlier, furlough is very much something that has to be agreed between the employer and the employee. If the employee wants to ask to be furloughed in those circumstances, then they can do, but the business doesn't need to agree. The government guidance at the moment does specifically talk about individuals that have been made redundant, and does confirm that employers can rehire them for the purposes of furlough, but there's no obligation on the employer to do so.
Okay, I think that answers that one. An email in from Paul Grace here. So Doug, if you can maybe answer this, maybe not, but do we have any further details on the bounce back loan? So Paul, if you missed the start of this, we were talking about what the bounce back loan is, announced last night. Effectively loans for businesses that are outside the grant funding, and the government will take on all the liabilities for the first year. We've also discussed with Doug a number of points about guarantees and who would be responsible for that. So if you're a limited company, you're guaranteed by the company, but if you're a sole trader, an individual, obviously it might be a house that's used as collateral there. So the question is, do we have any further information on this? Will SMEs access it through the British Business Bank CBILS process, or will it be accessed directly from the government HMRC? Can you bring us up to date on that, Doug?
Well, I can, because as you were reading the question out there, I was on the government.gov.uk webpage looking at what they'd said about it, just to see whether they said it'd be accessed. And unfortunately, the best I can say is where it says how to apply, it says the bounce back loan scheme will launch on the 4th of May 2020, and more information about the scheme will be published shortly. So that's the best I've got at this point. Although we will naturally be doing some digging to see if other commentators have got an idea of how it will be accessed.
Okay, I'll take this next one, again anonymous, but thanks for your question. People in Malham are upset that people are coming during the pandemic. Is that the right message to put out there, because visitors will be required in due course? Okay, so Malham and Malham Cove in particular recently won our World Cup of Yorkshire Natural Landmarks, and quite rightly so. A stunning piece of physical geography in our county, something that we're very proud of, a place that receives worldwide acclaim and visitors from all over the world. But people are upset that people are coming during the pandemic. So at the start of this, Welcome to Yorkshire put out quite a strong message, which was completely contrary to what our raison d'etre is, which was don't come to Yorkshire, don't leave your house, stay at home and stay safe. But naturally, people are still allowed their hours exercise, so we wouldn't ever suggest that we could tell people in Malham or the wider Malham or the wider area that they couldn't come out for some exercise as well as they're observing social distancing. But I suppose the question that is being asked is, should people go out of their way to come to Malham on a weekend, especially with Easter just having gone by, or an evening for a walk or some relaxation? Malham Cove isn't going anywhere, and it's our job at Welcome to Yorkshire to make sure that we still celebrate it in all its glory, but visually, digitally, theoretically, and make sure that people are ready to visit when the pandemic passes. But I think people do understand the message that we're saying don't come back yet. Don't come back just now. Welcome to Yorkshire probably will rebrand themselves as Welcome Back to Yorkshire when this passes, and that's the right message. At the moment, don't overcrowd these places. Not just because we're trying to observe social distancing, but the shops in Malham are closed. An influx of people into these villages where people live also puts a stress and strain on the local infrastructure, plus puts them at risk as well. So our message from Welcome to Yorkshire would be, please don't visit right now. However, celebrate in the fact that when this passes, you can come back when it's safe to do so. And it goes back to the question from Roddy. I think open spaces will be the first places that the government will push as safe tourist destinations. However, we have to measure supply being able to keep up with demand. If we all want to go to Malham Cove on the same day, can it cope? And I think that's a question. So visitors will come back to Malham irrespective, and I think they would come back tomorrow if they were allowed. So thank you for the question, but I think it is the right message to send out, and when it's right to say welcome back to Malham, we will be pushing that message for you, so don't worry about that. A couple of other questions I'll read through. So we've done the employment one, we've done Paul's. I'll read this out from Fiona Gardam. Fiona has been active with me on Twitter recently about a particular issue, and I'll open this up to either of you. But again, if you're not fully up to date, maybe I can come in. But I'll ask the question. So Fiona is a bed and breakfast owner. She owns the 1897 bed and breakfast, which I am coming to, Fiona, by the way, when this all passes, as long as you let my kids come with me. So Fiona is a bed and breakfast owner. It's a residential property, so she pays council tax as opposed to business rates. And 3 or 4 weeks ago, the Chancellor and the government announced the £10,000 grant available for businesses, small businesses that were paying rates as opposed to council tax. Fiona and thousands of other bed and breakfasts across the country don't qualify for this. We have written a letter to all Yorkshire and Humber MPs to raise this issue, to amplify it on a bigger scale. We've written to the Chancellor. As of yet, we haven't heard back on that particular issue. And we probably have to stop at this point and go, there's the issue. There is certainly some unfairness here, and Fiona can speak more eloquently on this than me in terms of how the discrepancy seems obviously unfair at first glance. And following up her question, she is appealing with regard to her business rateable value, as she believes she was wrongly kept in the council tax band. Okay, fine. But is there any advice on appealing the 10k grant, as the council have some discretion on this? So Doug or Hannah, anything to add to this? Are you aware of the issue? And any advice for Fiona other than her own lobbying with the MP using Welcome to Yorkshire? Perhaps either of you have got an opinion or some specific advice you can offer Fiona?
Shall I? I'll jump in because it's more on the restrictions obviously side. I'm not 100% sure if I'm following whether it's an appeal of the tax banding, in which case that would be more of a real estate lawyer's ambit. We need to know a lot more about why, what, where and when, or a rating surveyor may have a better answer to that, or if it's
so that is part of the question, the second part, and the first part was with regards to falling between the cracks of not qualifying for business rate relief, but yet being an identical business. So you and I have a business, Doug, we're both bed and breakfast owners. It just so happens that I pay council tax over business rates, and Fiona is of the latter, the former, sorry.
Yeah, I mean, and I agree. I was aware of this issue from one of the last seminars, and we've looked at it extensively again this morning to see if there's any further press release or update. And unfortunately, we can't see that the government has said or done anything to address the discrepancy. I suppose one answer is it's all very fast moving and they can't cover everything, and there's a conflict between getting broad swathe legislation out and then it will miss nuances, or taking time to get it right, in which case people don't get the money in their account. But I'm aware of the issue, but we haven't seen, having looked, any updates in relation to that issue yet. Yeah, it's a real sore point for Fiona and many others, and I suppose it's clearly something that the government are reticent to answer, and there must be a reason for that, Fiona. We're all doing as much lobbying as we can on this, and as Doug mentioned, things are so fast moving that hopefully it will change in the next 24 hours. We spoke with Alex Sobel last week, who's putting your specific point in front of the Commons this week. I suppose the flip side, so if I could hear Fiona speaking now, and I can in the back of my mind, it would be, we can't wait. It's hour by hour now. We may go out of business, which is a reality, and I think Rishi the Chancellor referenced that last week, that we probably won't be able to save anyone. But Fiona, rest assured that we will continue raising this issue for you until we either get a blank no, or there is some light at the end of the tunnel. There's a couple more questions coming in. And I'll just reference a couple of these before we look to our producer and see if we've got any more time. So this is from Karen Orker. Good afternoon, Karen. So what if a business needs the bounce back loan in a few months? So Doug, it's for you, this one, when the funds have dried up. Can an application be made at that point? So I suppose the question is, do you need to apply for it right now, or has there been some timescales set on when the cut-off is going to come in? Again, there's not a lot of information in terms of that. The scheme doesn't open to the 4th of May, so you obviously can't apply for it now. What I've found since we last touched on the application is, as a government press release that says the loans will be easy to apply for through a short standardised online application. The scheme will launch for applications on the 4th of May, and firms will be able to access these loans through a network of accredited lenders. What it doesn't say, though, is how long the scheme will be open for. But I mean, where I get to, if it's, well, I suppose it's interest free for 12 months. So the sooner you get the loan, the sooner the 12 months will expire and you'll have to pay interest on it. But the kind of mantra we give as restructuring lawyers is that cash is king, and so it would seem sensible, if you're going to need the money, to apply for the money, because there could be delays in the processing and paying out. We've seen criticism on CBILS for that, and for money not getting into bank accounts quickly, and B, yes, you're right, the government, depending on how the economy fares and how it's faring, may bring the scheme to an end. So I guess, without knowing the specifics, I can't be too specific in my advice, but if you follow those general principles, I wouldn't necessarily delay if you are going to need that cash. Okay, so we've got time for 2 more questions, one for each of you, and only because it came in before Hannah's question. Doug, this is again anonymous. You may or may not know the answer to this, but I'll read it. I understand that there was a grant of £25,000 for accommodation businesses. Is this automatic, and is it a right, or is it up to the local authority's judgment and discretion? Okay, so that, to me, I think we're talking here about the retail hospitality and leisure grant, which is available to businesses with a rateable value of over 15,000 but below 50,999, and it's grants of up to £25,000. If you're less than 15,000, there's the Small Business Growth Fund grant of £10,000 available. In terms of whether it's discretionary or not, I'll need to come back on that, but I happily will come back on that and feed in if I can. Yeah, brilliant. Thanks for that, Doug. And then the last question before we wrap up, unless any more come in, and this is for you, Hannah, hot off the press. Can
can we clarify that if an employee is made redundant whilst on furlough, they will be entitled to pile-on? And do we as a business need to pay that, or can we use the funding from the government under the job retention scheme? Also, should notice pay be at full pay prior to furlough? So if you can explain what pile-on is, I understand it, but in case anyone doesn't, if you could. And then the question is, please can I clarify, if an employee is made redundant whilst on furlough, will they be entitled to pile-on, etc. Also, should notice pay be full pay prior to furlough?
Yeah, so pile-on is payment in lieu of notice. Regardless of furlough, whether an employer has the right to make a payment in lieu of notice rather than requiring an employee to work their notice period will depend on what the contract says. So I'll deal with the question more generally in terms of notice rather than specifically a payment in lieu of notice, because that always depends on what the contract says. So if an employee is made redundant whilst on furlough, then you should give notice. The employer should give notice in accordance with the terms of the contract. So whatever the notice period is under the contract, that should be given. Taking into account there are statutory minimum notice periods in any event, which would need to be given at the very least. If an employee is furloughed, then yes, they can remain furloughed, or the government guidance at the moment certainly suggests that they can remain furloughed for the period of their notice. Whether it should be at full pay prior to furlough or at the 80% / £2,500 cap that is in place if they're on furlough, that very much is up in the air. There is very little commentary, very little guidance on it, and I mentioned it earlier on in the webinar. It will depend, or will likely depend, on what their notice period is. It depends whether or not it's the statutory minimum or whether it's a certain amount more than that, and it will also likely depend on the reason for furlough in the first place. So unfortunately, in relation to the final part of that question and whether notice pay should be at full pay prior to furlough, I'm afraid I don't have a yes or a no answer, and I don't think that there is a yes or a no answer available based on the current government guidance that we have.
Okay, thanks for that. And as we mentioned, Hannah and Doug, and to anyone listening out there or watching online, any specific question that we haven't fully answered, we're happy to do so offline, and you can contact us via. Sorry? If
there's 2 minutes, I can come back on a couple of the points that I've come back on.
Yeah, go for it.
So for the self-employment relief, we talked about how you calculate the level of income or how the HMRC would calculate it. So I'll just read this. You'll get a taxable grant based on your average trading profit over the 3 tax years ending 17, 18 and 19. To work out the average trading profit, we'll work out together your total trading profit and losses for the 3 tax years and divide by 3. If you've not submitted self-assessment returns for all 3 years, they'll work out the average trading profit based on continuous periods of self-employment, which will either be 80% of your average trading profit divided by 12, giving a maximum monthly amount up to maximum £2,500.
Okay.
And the other one, the question about whether or not the grant was discretionary, I thought I had seen a message saying that we don't think it is discretionary, and if you hit the criteria, you should be entitled to get it. But can you take that with a slight health warning? And I just need to confirm it, but that's our initial understanding.
Yeah, that's fine. And if anyone wants to jump on info@yorkshire.com with any particular follow-up questions or any specific detail, I'm sure that we can share Hannah and Doug's email addresses with you. So that draws to a close our webinar this afternoon in conjunction with Irwin Mitchell, and we do appreciate Hannah Boynes and Doug Robertson from the law firm for joining us this afternoon. We appreciate that you're Y30 partners, so we appreciate that, and thank you for your continued support. If you'd like to find out more information about their services, please visit www.irwinmitchell.com. As mentioned at the beginning, we'll be doing more webinars if businesses in the wider spectrum of Yorkshire are interested. We've had 10, 14, 15 questions this afternoon, so it's been very worthwhile. But any further questions, as I mentioned, jump on our website, yorkshire.com/latest for all our latest news, yorkshire.com/vouchers to access some of the vouchers that we mentioned for some of our members. And of course, you can follow us on social media. If you do, please use the hashtag Yorkshire together, so we can keep up to date with what everyone's doing. So that's it. Thanks, Hannah. Thanks, Doug. I've got to say, because everyone does, stay home and stay safe, and take care, and we'll speak to you all again. So all the best. Thank you very much.
Thank you.
Thank you.